good afternoon and a huge welcome to the final Your Employment webinar of the year, within which we will provide you with essential employment law and HR updates. For those of you that are new to our webinars, we are of course Jones Chase, a firm of specialist employment lawyers, and we act for a number of companies from PLCs all the way through to startups and also some fantastic individuals as well. We have a very high success rate of looking after those that we represent even, and we are delighted to have you with us. And just before we get into the legal content, I'd like to quickly introduce the team so everyone knows who's speaking today. And from my screen going clockwise, we have Dominic, our new paralegal. So say hi, Dominic.
Hi.
And we have Catherine, our new associate solicitor.
Hi, everyone.
And Carl, one of our senior associates.
Good afternoon, everyone.
And Shona, one of the firm's partners.
Hello, good afternoon.
Okay, and thanks everyone. And in terms of the format for the webinar, if you want to ask us questions, please do so. Please use the Q&A box. If you want to do that anonymously, please click the box to allow that to be done anonymously. It should be some self-explanatory. If you don't mind your name being displayed, you can use the chat box as well, but the Q&A may be a bit easier. And there's also an option which we find quite useful, where you can select between choosing all panelists or all panelists and attendees to see a question, and we quite prefer you to use the all panelists and attendees option if possible. Everyone can see what you're saying, and it's quite useful to keep the chat flowing. If you want to speak live, and only one person in 2 years has done this, please write into the Q&A or chat box that you'd like to do so, and either myself or one of the team will unmute you. I should add that we are recording the webinar, and this allows us to reach a much wider catchment of people from those who can make the 4 p.m. slot today. So please do bear that in mind, and particularly if you're asking questions on a non-anonymized basis. I should emphasize that the points that we're covering today are not formal legal advice, and so much depends on the facts of the case, and the approach that you take in one case will differ in the other, and a whole load of commercial factors as well. So please do not rely upon this webinar again for legal advice, and do get in touch with us instead, and we'd love to help you. As a quick reminder, things are moving quickly as ever, and the information that we're covering today is accurate as of 4 o'clock on the 16th of December 2021. Things are changing very quickly, and again, do drop us a line if you have any questions. So we appreciate that everyone's time is precious, and depending on how well the quiz goes at the end of the webinar, we're hoping to finish at 5 o'clock today at the latest, if not before. And lastly, we do like helping people, so if you have any further questions, or if you know anyone else that would like these webinars or benefit from working with us, and please do pass those details on. You can reach me at dean.jones@joneschase.com. And we do love getting referrals, and we'd be very grateful for that. So thank you very much. Okay, so moving very quickly on with the content, which this reminds me of one of my favorite quotes from the Godfather movie. Once you think you're out, they pull you back in. And on that note, Dominic's going to let everyone know what the new government rules are about home working. So over to you, Dominic.
Thank you, Dean. So I will be looking at a new government guidance that was announced last week on Wednesday, the 8th of December, 2021, regarding working from home if you can, the changes to the isolation and testing rules, and what you need to know as employers. So firstly, from the 13th of December, 2021, the government has advised employees in England to work from home where possible. Secondly, on the 14th of December, government regulations were amended to remove the distinction between the close contacts of a known or suspected Omicron case and close contacts of all other positive cases. So this is obviously important to be aware of if your staff are still coming to work but have been required to isolate. All close contacts, regardless of the variant, will no longer be required to self-isolate if they are fully vaccinated, taking part in a vaccine trial, or can provide evidence that they cannot be vaccinated for clinical reasons. So anyone falling within those categories who was in a period of self-isolation before the 14th of December 2021, due to a contact with a known or suspected Omicron case, could end their period of self-isolation at that time. So government guidance is being updated to recommend that those who are fully vaccinated and identified as a contact of someone with COVID, regardless of the variant, should take a rapid lateral flow test every day for 7 days. Anyone whose test comes back positive or who develops COVID-19 symptoms should self-isolate and take a confirmatory PCR test. If the PCR test is positive, they must self-isolate for 10 days from the day they took the rapid test or when they develop symptoms. they do not need to continue taking rapid tests during that period. However, if the PCR result is negative, they can leave self-isolation, but should take rapid tests for the remainder of the 7 days. So looking more at the requirement to work from home. So of course, anyone who cannot work from home should continue to go into the workplace. And examples of this do include the need to access equipment necessary for their role, or where their role must be completed in person. Additionally, in-person working will be necessary, of course, in some cases, to continue the effective and accessible delivery of some public services and private industries. So if your business does require your workers to continue to go into work, it is advised that workers should consider taking lateral flow tests regularly to manage the risks, possibly twice a week, even if they have not been a close contact. If this is something which potentially creates animosity amongst parts of the workforce, it can potentially create legal risks, albeit they are low. Staff cannot be forced to take their test, of course, and they may see the procedure as somewhat invasive or unpleasant. And one of the low risks is that workers resign and claim constructive unfair dismissal. With regards to discrimination, there are few, if any, valid religious objections or medical conditions preventing testing that are capable of amounting to a disability. But if as a business you opt for workplace testing, whether that be in a separate room or entrance to your building, this isn't as straightforward, unfortunately. Considerations will need to include who is going to take the test. Are they going to be self-administered or conducted by a professional? All lateral flow test results taken via workplace testing must be registered with Public Health England, which can be done by phone or online. Processing test results will also constitute processing sensitive health information. As such, you will need to consider your data protection obligations, such as have you informed and consulted with the staff in an open and transparent manner about the reasons for processing their personal data and what decisions will be made as a result of you having that information. We did produce guidance on our website in July 2021 on whether an employer can legally require their staff to take a COVID test. If you have not had a chance to view this, please do. Alternatively, I can provide a link for this for convenience. And whilst working from home is enjoyable for some, it may not be for others, and a mental health pandemic began to emerge during the first 2 lockdowns. Therefore, employers should consider whether working from home is appropriate for all their workers, especially those facing mental or physical health difficulties, but also those with a particularly challenging home working environment. The government intends to regularly update its working safely guidance for employers whose workforce cannot work from home for whatever reason. Interestingly, it has been reported that some employers are planning to take a more flexible approach to the government's advice for employees to work from home where possible, compared to what they did earlier in the pandemic. Taking into account the psychological impact of prolonged working from home, employers such as PwC and Slaughter and May are advising employees that they can come into the office for mental health reasons. As I said at the beginning, it is only advice from the government to work from home rather than a statutory requirement. There are various legal obligations for employees to consider when staff are working from home. Unfortunately, we do not have time to delve into these areas with any specific detail, but by way of an overview, employers will owe a duty to take steps that are reasonably necessary to ensure their employees are working in a safe environment. This does include safeguarding mental health and well-being, as discussed earlier. Secondly, data security will need to be considered as well, and employers should be confident of the security of the equipment they provide their employees, such as laptops, mobile phones, and the systems that are being used. Thirdly, employers should provide equipment for their employees in order to facilitate their ability to work from home. This can be a considerable expense for some employers, but additionally, laptops and mobile phones used from previous lockdowns can once again be used. Disabled employees should also be considered by employers to see if there are any reasonable adjustments which need to be provided under the Equality Act of 2010. And finally, employers may need to consider the monitoring of their employees once again whilst they are working from home. This was discussed in our previous webinar in November, which is available on our YouTube channel, and the advice will most likely be bespoke for each individual business. Of course, if you would like to discuss any of these legal obligations in the circumstances of your business, please do let us know. But in order to comply with these obligations mentioned, Jones Chase does strongly recommend a home working policy is put in place for their employees to accommodate any temporary home working arrangements that do exist post the government's Plan B measures. The policy should encompass the issues mentioned, as well as a provision to terminate the home working arrangement. Furthermore, we also advise updating your employee's contract, adding a temporary home working arrangement clause. This would help with issues where an employee wants to remain working from home after the temporary measures have ceased. If you do not have this clause in a contract and would be looking to implement this, please do let us know, and we can also assist with the contract variation process as express consent is necessary. Otherwise, employees may gain an implied contractual right to work from home, which can cause problems for the business once the guidance stating that you should work from home if you can is lifted. And as I previously said, if you do require any assistance on what I've discussed, Jones Chase will be happy to help. That's all from me.
That's fantastic, Dominic. Thank you so much. And yeah, it's, as a quick reminder, a lot of you have been attending these webinars for quite some time now. We've covered all of these points before. It is familiar ground that we're all in at the moment. A bit disappointing that it has happened, again, I suppose. But the rules are a bit different this time, as Dominic has said. There's also a load of content on our webpage in the news and events page. And so please have a look back there. If you have any specific questions, do let us know. And as we've said in many webinars before, getting the contractual position right is very important. Also having a good home working policy, we think is essential these days as well. And just reminding that topic of confidentiality is very important, and obviously looking after your employees' mental health, all of which we've covered before. Well, we just had a quick question before we move on. And okay, this, I think it's from Samantha. So should we notify our employees who've been in contact with colleagues who've subsequently tested positive for COVID of this fact? Does anybody from the team have an answer for that?
Well, I would just, the individual themselves will be asked to give the contact details of who they've been in contact with. So the person who's tested positive, the obligation is on them. You would slightly worry that if you were giving the information that you would then breach confidentiality of the person that's tested positive. So I would remind the person who has tested positive that it is their obligation to give the contact details of those they've been in contact with. I'd do it that way round. I don't know about anybody else.
Yeah, that's right. And I think quite often health and safety does trump other rights in many circumstances. And if there's a health and safety obligation to notify other people within the business, that could trump any individual right potentially. But of course, getting consent from the individual as well is a surefire way of getting it done and really lowering the risk, because you can say to that person that we have to tell people this has happened. Do you agree? And that person realistically should say yes. If they say no, drop us a line. We're more than happy to help you with that particular little conundrum. But yeah, I mean, there's definitely ways through and a solution that can be found.
Yeah.
Okay.
The other thing that's cropped up this week has been the unvaccinated. So individuals worried that they're working with people who are unvaccinated, and it's those people that are going into work either because they have to or for work reasons, or they are going into work for mental health reasons. And that's quite a problem again with individual rights and health and safety. But the advice being given out this week is to try and see if the individual who's unvaccinated will work in an area that's away from others. And they've chosen to be unvaccinated, and therefore let's find alternative ways of dealing with this.
I mean, one thing, I mean, so it may be that if the employee who's tested positive doesn't have the contact details of colleagues, I mean, you'd expect them to have their email addresses, but they may be on holiday now and not monitoring their emails. And so one thought I had was that you as the employer could write to the employee that's tested positive and say, if you struggle in knowing the contact details, as in the work email or work mobile number, then let us know, and we'll check with those people as to whether they consent to us sending you their mobile number. Some And then basically picking up what Shona's saying as well, and Dean, you try and get the consent of that individual. If that individual for whatever reason doesn't reply or says no, I'm not bothering with this because I've got some colleagues who are friends of mine, they don't want to be pinged and have their Christmas ruined, then I wonder whether what you could say is it's legitimate management instruction we're giving you that you do notify these people because you've been tested positive. They may well also be positive. They need to know that there's a risk that they could be, because they could make other, they could infect other of our colleagues if they're still coming to the office. And if that person refuses, whether you then take disciplinary action, but do reach out to us if in that unlikely event arises, because there are sort of sensitivities involved. And in terms of the argument about confidentiality, I suppose then one would give thought to whether or not that they could rely on confidentiality to prevent you from mentioning the positive test result to others on the basis of the argument would be that actually they're in breach of their own obligations or perhaps coronavirus regulations. There's no confidentiality in iniquity, so you can't rely on confidentiality if you're trying to use it to sort of cover up a breach of a statutory wrong.
That's right, and thanks, Carl. And just something to add as well is that each situation is so incredibly individualistic, and this person may very well have good reasons for not wanting to share information. So again, if you are encountered with this, I would say it should be quite rare that it could happen. Definitely drop us a line and we'll find the solution for you in the specific set of facts that we're working with. Just before we move on, because we are running out of time as always, we've had a quick question in from Paul, and he's saying, is there still a need to inform Public Health England of all positive cases? That isn't not necessarily an employment related question. I don't know if you know if you came across the answer with your research, if anybody else knows, but my understanding is the individual has an obligation to notify the government via the test and tracing thing if they test positive, that's my understanding. And then from the employer's perspective, if you're carrying out testing in employment, I think there's an obligation to notify public health then. Does anybody else from the team have any views on that? But I think most organizations don't test their staff. They rely on people to do it on an individual basis or privately.
Can I just go back, Dean, to your point about the health and safety, and then following on from Carl? You know, if we look at this at the worst case scenario, and that's usually when we get involved when the worst case occurs, and your point about the health and safety being paramount, if we have a situation where the individual doesn't want to contact people for the reasons that Carl's given, and so we're stuck with the information that somebody has tested positive, and we know that they're not informing them. Your point about health and safety being paramount, particularly for the organisation, is if a relative of an individual then dies because they've been in contact at work with someone who's tested positive, they then become positive and somebody dies. There could be a chain of causation where we are then liable for that ultimate death, we being the employer in that scenario. So you're right with the health and safety point being paramount. So if you've given the individual the opportunity to do this and they're not, then the obligation is on us, I think, to provide that information with what we know, and having tested positive with an employee. I know that's doom and gloom, but it could be an ongoing.
No, I think you're absolutely right, Shona, as well. And yeah, just going back to Paul, we could have a quick look at this would be in the relevant government guidance, but whether there's a need to inform Public Health England more positive cases. That would be on the individual as well. And like I said, it's different on the employer. It's only if the employer is carrying out workplace testing, I understand there's those obligations in that regard. If that is not correct, we will email you to give you the right answer. Okay, well, moving quickly on as we're running out of time as usual. Just to hand over to Shona, who's going to speak to you about, and this has actually cropped up for me in the last 2 weeks. I've seen a few things about this as well, about the use of facial recognition technology within employment. So over to you, Shona.
Okay, thank you, Dean. This is about digital management, which occurs with algorithms, artificial intelligence, and machine learning. And it crops up in areas such as recruitment, where you can be recorded when you're being recruited as part of that interview process, and your facial recognition's analysed to see if they match what's needed within that organisation. Say it's an organisation that deals with the public directly, as an example. It also comes up with task management, so and the allocation of tasks within the organisation. and who they're allocated to. And there's an actual Uber case, which we'll come on to, that covers that. And then monitoring, so monitoring employees with this digital management. Now, within digital management, there are all sorts of ways of providing technology to assist you in how you're managing your employees. But I'm going to deal with this facial recognition technology, that's FRT, that is the subject of today's talk. So facial recognition has come up in a case with Uber, where the drivers, when they accept a fare, they have to have a photograph of themselves taken at that time to ensure that it can be matched with the photograph that Uber has on record for that driver. The reason it was introduced was in order to prevent someone substituting for the driver, and that substitution was not licensed under the license regulations, and those license regulations offer criminal records, etc. And so it's for the protection of the person that's taking the cab journey. So we've got a picture being taken, and that picture is then matched with a picture of the person that says, I am X, but yeah, that's okay, and they can do the drive. Uber used this facial recognition for all its employees, and it came to the attention of some of the employees that they were getting their photos that they took on accepting a ride rejected. And when this was checked in relation to the profile of those drivers, it was mostly people of colour that were having their photos rejected. Now, rejection meant money, because if you had your photo rejected, it meant that you were taken off the system for acceptance for rides for a certain period of time. And if there was a continuous rejection and you weren't able to match your photo with that on record, it meant that you could even be suspended from having work allocated to you for a particular period of time until it was checked by a human being to make sure that that photo did match the photo that they had on record. And being checked by a human being took days, not the seconds that the technology took. And so individuals were losing out on money and their income as a result of this facial recognition. And 2 claims have been brought in the Employment Tribunal to say that this facial recognition technology is therefore indirect race discrimination. So there is a practice, condition, or process that's been put in place to try and comply with the licensing requirements relating to who's taking that ride. And this condition has an impact on a particular set of people, and that is potentially race discrimination, and that the organisation cannot legitimately excuse why they're using that particular technology for that process. Now, the intention of the organisation, the intention is to keep passengers safe, is actually irrelevant when it comes to indirect discrimination on the grounds of race, or indeed any kind of indirect discrimination claim. But the intention can be fitted into this is a legitimate process that we're using, and it's proportionate to the aim that we are trying to create a safe environment for our cab riders or the people that use cabs for us. This is at the Employment Tribunal at the moment as to whether it is indirect discrimination, and whether Uber can defend that as a piece of technology is therefore going to be argued in the tribunal system. But one of the things that it will have to show is that they do have this legitimate interest, and also that they had the employee's consent, or in Uber's case, it's a worker's consent to the use of this facial recognition technology. And they will be asked, or as part of that case, what alternatives had you put in place, or did the workers know of as an alternative to using the facial recognition? Do you have another system in place so that if there is a problem with that technology, you could use an alternative? And or is any of your technology backed up by human interaction? And that human interaction has to come in a timely manner, not 2 or 3 days later after you've been rejected by the technology. The other suggestion that's made in terms of the use of facial recognition and whether indeed it's a legitimate use is have you contacted the ICO in advance to discuss with them the use of this technology and the impact on your workers and or employees? And if so, what was the ICO's view on that? So there's just ways that you can justify the use of the technology, making sure the consent from the individual concerned, making sure that you've given alternatives, making sure that you've contacted the ICO in advance, and that you've got a legitimate interest that you need to protect. And in this particular case, that legitimate interest is the prevention of people without a criminal record accreditation being on file as a driver. So I think we're going to be talking in 2022 a lot more about digital management and its impact on employment practices. So thank you, Dean. I'm going to enjoy that, actually. It'll be interesting.
That's great. Thank you so much, Shona. And whilst we've been, yeah, it's going to be incredibly interesting, absolutely. And just before we move on to the next section, so Dom's been furiously researching in the background. He just sent me an email to confirm that, yeah, indeed. So with workplace testing, our understanding is that all lateral flow test results must be registered with Public Health England, and that can be done online or by telephone. So again, that is relevant to workplace testing, and not, as far as we're aware, with people doing individual tests. So just to get back to you in that poll, okay? Something else I forgot to say at the start, I do apologise as well, is that we are doing a series of the A to Z of employment law in 5-minute videos. And we've had a very busy December, actually, so we're a bit late getting the next instalments to you, but rest assured that we will be continuing with our 5-minute videos, the A to Z of employment law in 2022, and we're going to have 2 videos going out in January, one from me and one from Dom. So I've said it now, it's in the public domain, so we have to deliver on that. So there we go. And I apologize that we haven't had any in December. Just moving quickly on, we thought that we would do something something festive, if you can put it that way, in terms of employment law. Also, certainly something of the time of for December, which is the issue of Christmas parties. And Carl's going to discuss how far the concept of vicarious liability for employers extends in the Christmas party environment. So Carl, over to you.
Hello everyone, and I appreciate that some of you may have had your Christmas parties, others may have had them postponed or have decided not to attend in the light of rampaging Omicron. So normally for employment lawyers, we get quite excited in January if there have been some raucous Christmas parties, because one always has to consider the extent to which an employer is liable for the acts of its staff at a Christmas party. So I'm asked to comment on how far does vicarious liability extend for employers when it comes to Christmas parties? Are you responsible for everything your staff do? And I think it's just want to spend a second explaining how the law operates. So there are 2 sort of sources of liability for an employer. There's the first one that you may well have come across, which is liability under Section 109 of the Equality Act 2010, for acts of employees that are carried out because of one or more of the protected characteristics under the Equality Act, so race, sexual orientation, religion, belief, disability, gender reassignment, maternity or pregnancy, age, religion, belief, and I'm sure I've missed one of them, gender. And then the question then is, has the employee in their course of employment carried out an act or an omission which gives rise to a liability under the Equality Act, and if so, and if the employer cannot rely on the statutory defence in Section 109 subsection 4 of the Equality Act 2010, i.e. the employer can't show that before the act of discrimination occurred they had taken all reasonable steps to prevent the employee from carrying out the act of discrimination. They can't show that, then the employer is liable. It's known as constructive liability. That's different from vicarious liability, and the reason for that is that the way that the Equality Act works is that the liability attaches to the employer as a sort of co-wrongdoer. The employer is deemed in law to be a sort of primary wrongdoer. And that, however, is a claim that can only be brought by someone who says that the reason for their treatment was one or more of the protected characteristics. So in situations, for example, a Christmas party where you may have, just take purely as an example, you may have a white female lady who assaults a fellow white female lady. The victim can't say that the reason for my treatment was my gender, because she might be able to say that. She could allege that, but it may fail because it's not clear that the reason for the treatment was her gender. But so that victim of the assault at the Christmas party could, in addition or alternatively, say that you are vicariously liable, i.e. the employer is vicariously liable under what's known as a common law vicarious liability, which predates the Equality Act 2010 and goes back to Victorian times. And so it rests on the notion that if you are an employer and you have an employee or someone in a relationship that is akin to employment, then you benefit from that person furthering your business aims, and in response, in return, you're liable for the risks that are inherent or that arise from the fact that you are bringing this person into your business, holding them out as being connected to your business and doing work for you to further your aims. And the law has established it doesn't have to be for profit. You can be a charity and still be vicariously liable. You can be an unincorporated sort of badminton club, not raising any cash really, and still be vicariously liable. It's quite broad ranging, and it rests on the notion that someone that you bring into your business, either as an employee or someone in a relationship akin to employment, if they carry out a tort, so negligence or a theft, it could be a criminal act, in a situation where that is part of their activities, which is so closely connected to their employment or relationship that's akin to employment, then the employer is liable unless the employer can show that the individual was on a frolic of his or her own. So there are two sets of tests, two different sources of law, and the question I've been asked is vicarious liability, but I wanted to explain that to you. So if we look at this, I mean, there's lots of case law which has held that employers are liable for the acts of a fellow colleague or employee that being carried out in the course of employment at a Christmas party, i.e. that the Christmas party was arranged by the employer, it was funded by the employer, it may well have taken place on the employer's premises. Whether it has or not is not determinative in and of itself, it's just one of the characteristics that you take into account in deciding whether it is in the course of employment. I'm reminded of a case that actually fell under conventional and vicarious liability common law principles. This wasn't arising in the context of the Equality Act 2010, and it's called Bellman versus Northampton Recruitment Limited, 2018. Court of Appeal decided that the company was liable for the actions of a managing director where he violently assaulted a junior colleague at an unscheduled drinks event that took place after the workplace Christmas party. So this was at a time after the Christmas party had officially ended. They'd gone back in a cab to a hotel for further drinking, and during that time the managing director's decision making in relation to some project was challenged, and he with relation to one of his male subordinate colleagues, he violently attacked him, and then that colleague brought a claim saying, you're vicariously liable, you've got to pay for injury sustained, personal special damages and general damages under the personal injury law. So the employer said, well, wait a minute, it's not our fault. This wasn't at the Christmas party, this was at a hotel after the Christmas party, it officially ended. So under the vicarious liability principles, there wasn't a close connection between the relationship of the managing director and the company and the wrongdoing, which was this violent attack at a hotel. The connection had been severed because it was not on workplace premises, it was beyond the scheduled working hours, everyone was off duty, and it was their decision to go to the hotel, we had no control over it. But the Court of Appeal decided that that didn't work, and that there was it was closely connected to the employment of the managing director, because the way to do this is you look at the sphere of activities, you look at the actual authority that's given to the employee that's accused of the attack, which is the principal wrongdoer, i.e. the managing director in this case, and you look at what he or she's has been tasked to do. And then you look at this sufficiency of the closeness of the connection between what they're tasked to do, what they're allowed to do under their employment contract, and on the ground. It's not just what the contract says, is what you have to look at what they're allowed to do on the ground, and you look at the closeness of that with the actual attack here. And what they said, the Court of Appeal in that decision, they said that the managing director is liable as a wrongdoer, clearly, because he's attacked someone, and the employer is liable under vicarious liability rules because he was pulling rank and he was explaining a management decision, and he was talking about work events at work, and he was with work colleagues, and there was a sufficiently close connection as well to the Christmas party. It was a follow-on from the Christmas party. So I wanted to raise that because, you know, it's quite clear that there are examples of cases where the employer is vicariously liable under common law vicarious liability principles for the acts of employees, not just at Christmas parties, but at unscheduled works events that follow them. And there's also been another case where an employer was held not to be liable for a
I think we may have just lost Carl there. Sorry, we'll just see if he comes back.
Just while we were waiting, just this week, I've advised on a Zoom call organised by the company where it was a Christmas party, cancelled in person. Let's have this on Zoom. And somebody has said something really quite derisory during the party festivities on Zoom. And I have said that was in the course of employment because it was the company's Zoom arrangements that they used. No one would have been there had it not been arranged by the company, and it was a replacement of the other party. So yeah, it's it is timely. Just it goes beyond the assault case that Carl's just talked about, which is quite horrific, but it is equally not nice to have discriminatory treatment even on Zoom.
Yeah, absolutely right. And I think whilst we're waiting for Carl to log back in, is I guess the reason why we wanted to do that, to have this chat is it's just a quick reminder that even the after party after the party could still be could still come back to the employer. And obviously at that time you've got little to zero control over what your staff are doing. So having a good disciplinary policy with some really clear rules on there can really help as well. And just to make it clear that with work-related events, you've got to behave yourself, essentially, and if you don't, there could be disciplinary action.
I suppose part of that also goes with hierarchy. If you're and after the party, I don't know how many after parties you had in your example, quite a few, but that's if you're still hanging around and you're the most senior person in the organisation, that you're only there because you are there because of the organisation, whereas if you're maybe contemporaries at the same level, whatever, that could be a slightly different argument, maybe.
Yeah, true. Absolutely true. And yet again, everything turns on the facts, really, doesn't it? And what happens specifically. But Carl's also right to say that this isn't just Christmas parties. Other events can be an extension of the work of the workplace arrangements as well. It looks like we may have lost Carl almost permanently. If he drops back in by the end of the web, it's the first time this has happened to us, but then again, it is Christmas, so something's got to be different. Okay, maybe what we'll do, we'll move on to Katie's, Catherine's section. We'll run through that if Carl joins us once again, then he can just finish off what he was going to say. So I'm just going to hand over to Catherine, who's going to run through some, the top legal highlights from 2021, and it's certainly been an interesting year legally. So over to you, Catherine.
Thanks, Dean. So yeah, well, my topic was 2021, a year in review. What were the key cases and legislative changes that you need to know about? So for employment law, as Dean was just saying, it's been an incredibly busy year, and I can't possibly cover all of the important stuff. Is that Carl coming back on? Maybe I'll let Carl finish his piece.
So sorry, everyone. I mean, deepest, darkest Sussex, and we just
That's right.
I really can't explain it.
We would just like to welcome the Ghost of Christmas Past back to the webinar. So, Carl,
spooky. Yes.
Okay.
I'm just conscious of timing, and I don't know if really what I want to say is, when it comes to this, are you responsible for everything your staff do? Well, the answer to that is it really does depend on what it is your staff do. So if they're accused of some criminal wrongdoing, in order for you to be vicariously liable, the staff member, him or herself, has to satisfy the liability for the criminal wrong. So if it's some sort of assault, they need mental guilt for, what's known as mens rea, mental guilt. They need to show that they've had that. Or so vicarious liability is a form of secondary liability. You're not going to be liable if the wrongdoer, him or herself, isn't charged successfully with the offences. So often with vicarious liability that rests on, say, criminal assaults, it's normally the employer that gets sued a bit later down the line after there's an earlier decision that the principal wrongdoer, the staff member's done something very naughty for which they've been found guilty. And then what happens is the individual says, well, I've been harmed, I want some money, where do I go for that? And they look to the employer's deep pockets for compensation. And often where it's quite high values that are being claimed, they often go to appeal, because why wouldn't you try and appeal it? So you often find this goes on and on. But under the Equality Act, it's easier to establish that something was done in the course of employment, and therefore, depending on the harm that's been caused, the employee might decide, I may as well just bring a claim to the Employment Tribunal. It's cheaper for me to do so. I don't have to pay the other side's fees in the event that I get it, that I lose, which they would have to pay if they sue for vicarious liability in the civil courts.
Okay, great. And just before we move back on to Catherine's section, Carl, nothing else to add at the moment? You've covered everything you wanted to, yeah? Because I know we were disrupted.
Yes, I think it's. I mean, whether you're accused of being vicariously liable for the acts of an employee or liable under the Equality Act 2010 for some form of discrimination, do get in touch, because there isn't a defence, a statute defence to vicarious liability under common law, but there is under the Equality Act. It's section 109 subsection 4, and so we can advise on that. And what's important is that, you know, you must have an equality opportunities policy or an anti-harassment policy. Circulate that to your staff, make it well known in advance of the Christmas party you have it, and that you expect everyone to behave in a civilised and respectful manner towards each other. And having that on an email will be useful audit trail that you've taken some reasonable steps.
Okay, fantastic. Thanks so much for your section, Carl. That was brilliant. And just moving back to Catherine's 2021 year in review.
Yeah, thanks, Dean. So I think I was just sort of saying it's been an incredibly busy year for employment law, and I can't possibly cover all of the important cases and legislative changes, but I picked up on maybe 4 sort of key cases with some good takeaways. The first I'm going to skip to, actually, it wasn't going to be my first, but just following Carl's piece on vicarious liability, and he's just touched on the defence. It's the section 1094 of the Equality Act defence. There was quite a good case on this year. This was the case of Ale UK and Gellen. This case concerned an allegation and a claim against the employer Ale UK by Mr. Gellen for racial harassment, and he alleged that he'd been racially harassed by another Ale UK employee. The company, Ale UK, attempted to defend the case and say it had taken all reasonable steps to prevent the harassment from occurring. This was based on what Carl mentioned, that section 109(4) of the Equality Act 2010, where if the employer can show that it had taken all reasonable steps to prevent an alleged harasser from doing that thing or anything of that description, for example, acting in a discriminatory way through the use of its policies or anti-bullying and harassment training and equality and diversity training, then an employer can be held to not be liable. The alleged harasser may still be liable, but the employer wouldn't be vicariously liable. But in this case, the EAT rejected the employer's all reasonable steps argument on the basis that the diversity training was provided to employees, including the alleged harasser, but almost 2 years prior to the alleged discriminatory conduct, and so would no longer be effective to prevent harassment in the workplace. And the EAT actually referred to the training as stale. So a really good take home from this. I'm sure this case has been mentioned a few times from us over the year, but it is a really good one to remember. You need to be carrying out regular anti-bullying and harassment training and equality and diversity training and refresher training. So online, in person, it can be over Zoom, it can be live sessions to promote a non-discriminatory workplace. And this case also demonstrates it's quite a high threshold to succeed in defending a claim for harassment using the all reasonable steps defence. So that's just a good add-on to Carl's section. And the next case I was going to have a little look at was the case of Bayfield and another, Wonderman Thompson Limited and others. So in this case, there was a reference made in a company conference to wanting to obliterate its reputation that it was full of white, British, privileged straight men. And this was after they had published what they described as a horrible and embarrassing gender pay gap. So subsequently, the agency, which was the company, made 2 of its straight white British male creative directors redundant. And the tribunal held that the redundancies were both unfair and sex discrimination. So this is just a reminder that the Equality Act is there to protect everybody, and seeking to fix systematic issues overnight just isn't going to work. You know, ultimately, men cannot be terminated because they are men, just like women cannot be recruited because they are women. So there are some very limited, rare circumstances where positive action is possible. But if you're thinking about this for your business, I would suggest you take legal advice, because it is, like I say, quite rare. And then another case I was going to look at, which again, we've probably been going on about it a bit this year, and we've had a whole session on menopause in the workplace, but it's worth repeating because I think it's going to be an ever-increasing topic in employment law, and that's the case of Rooney and Leicester City Council. So in this case, and it's a case of the EAT, so Miss Rooney alleged that she'd suffered from physical, mental and psychological effects of the menopause for over 2 years and disclosed many debilitating symptoms, including insomnia, fatigue, tiredness, lightheadedness, stress, depression, anxiety, and the list goes on, migraines, hot flushes. And she said that this made her unable to cope both physically and mentally. She eventually received a written warning for work-related stress absence, and the evidence showed that her appeal was heard by all men, or for men, and the occupational health didn't provide her with a female doctor, and she felt she had no alternative but to resign. So she brought claims in the Employment Tribunal for direct sex and disability discrimination, and at the first instance tribunals, her claims were actually, they weren't upheld, and it was decided she did not have a disability. So the case was then taken to the Employment Appeal Tribunal, who held that the Employment Tribunal had wrongly decided that a woman suffering from menopausal symptoms was not disabled. So while the case law in this area develops, we just think it should be very prudent to be wary and make sure your line managers are alive and to understand menopausal symptoms and the impact this can have on well-being, performance and attendance. And this is not only important to reduce the risk of a claim, but as recently highlighted in an independent report commissioned by the government, almost 1 in 4 women end up leaving the workforce and 25% consider giving up work as a result of the impact of the menopause. So it's important if you want to retain talent also. As a starting point, we'd recommend implementing a menopause policy just as a start. And then the final case I was going to go on to was the case of Coastal UK Limited and Dunkley and others. This was a Supreme Court case, and it was held that an employer's direct pay offer to workers bypassing a stalled collective bargaining with a recognised trade union constituted an unlawful inducement within the meaning of the legislation governing this area. So in this case, the trade union Unite was recognised by the company for collective bargaining purposes, and following negotiations between the two, the company offered a package of pay increases, a Christmas bonus, alongside some detrimental changes to the terms and conditions. When this was rejected by Unite's members in a ballot, the company wrote to all of its employees directly, offering the same package, and posted a notice saying that if employees did not agree to the new terms, they would forfeit the Christmas bonus. The company subsequently wrote again to employees, stating that their contracts might be terminated if an agreement could not be reached. Nothing was said about whether dismissal would be followed by re-engagement on new terms. So a number of the Unite members brought employment tribunal claims against the company, and they alleged that each letter constituted an unlawful inducement contrary to the legislation governing this area. And the tribunal upheld the claims in respect of both offers. So the Supreme Court did confirm that there is nothing to prevent an employer from making an offer directly to the workers, provided that the employer has first followed and exhausted an agreed collective bargaining procedure. But the Supreme Court did warn that an employer cannot do this, is make offers to the workers before collective bargaining process has been exhausted. And then finally, I was just going to do a little quick review of some of the key legislative changes this year. I know everyone's very excited for the quiz, so I'm not going to hop on for too long, but I just wanted to say quickly that the off-payroll working in the private sector, most commonly known as IR35, was introduced on the 6th of April of this year. And also there's been an introduction of the regulations which state that those working or deployed in CQC registered care homes must provide evidence that they have received the complete course of a proper vaccine against COVID-19 or provide a medical exemption. So these regulations are quite far reaching, and they don't just apply to carers, but they also apply to any individual entering the care home, with some limited exceptions, including those providing indoor maintenance, which does cover some of our clients actually. So it's been an interesting topic.
Okay, thank you everyone. That is the end of the webinar. We're just 1 minute past 5. Really appreciate you supporting the firm and throughout the year. Really appreciate you supporting us for this webinar project. Just a quick reminder that the information is accurate as of the 16th of December at 4 o'clock on the 16th of December 2021. It's been a real pleasure having you with us. And once again, if you know of anyone else that may benefit from working with us, please do recommend us. We do love referrals. And for me and all of the rest of the team, have a fantastic Christmas and New Year's, and we'll see you all once again in 2022. Okay, take care and goodbye. Thanks very much.
Take care, everyone. Stay safe.
Thank you. Happy Christmas. Bye-bye.
Happy Christmas. Merry Christmas and Merry New Year as well.
Happy New Year.